Presenting the Practice Pulse, a podcast production of the State Bar of Wisconsin, hoping to make your law practice work for you and not the other way around.
Welcome to episode 2 of the Practice Pulse podcast. I am your host, Brent Hoeft, practice management advisor at the State Bar of Wisconsin. You know, a common topic that comes up during consultations with members is legal malpractice insurance. There seems to be a lot of uncertainty surrounding this topic at many stages of the legal career. So in this episode, we'll explore all aspects of malpractice insurance. And joining us on this journey is Matt Beier from Wisconsin Lawyers Mutual Insurance Company. I hope this information provides a little clarity to the world of malpractice insurance. So let's dive in. Hello, all you listeners. Welcome to the next episode of the Practice Pulse. Today, I'm very excited to have with me Matt Beier from WILMIC. Matt, welcome. Thank you for joining me.
Absolutely. Thank you for the invitation, Brent. I appreciate it.
Matt, tell us a little bit about yourself. What do you do with WILMIC? What is WILMIC? I know people know the name, but tell us a little bit more.
Yeah, I think they know WILMIC more than our nickname, I guess, or at least our trade name, recognized as such, more so than they do Wisconsin Lawyers Mutual Insurance Company. That's a mouthful. But we are that. We are a mutual insurance company. WILMIC began in 1986. And it was really an effort by lawyers in Wisconsin confronting a shortage of realistic options for legal malpractice insurance. Those options that were out there from some of the bigger players, some of the bigger carriers, were either too expensive or just not tailored to fit the main population of the Wisconsin legal community, which is solo and small firms. And so Wisconsin lawyers did what Wisconsin lawyers do, and they started an insurance company. And the main goal of WILMIC is to provide, of course, legal malpractice insurance, but we also have, as part of our mission, doing whatever we can to support Wisconsin lawyers in their mission in providing professional and legal services to their clients. I joined WILMIC in 2016. I joined as a claims attorney. And I worked in that capacity for about 4 or 5 years. And we, as businesses do, WILMIC began to evolve and have different kinds of needs, one of which was a focus on business development. So at that time, we changed CEOs. Katya Kunska was our longtime CEO for, more than 15 years, but I think fewer than 20. But she was with the company much longer than that. So she was one of our cornerstones. And so when she left, she was replaced by Tom Watson, who has been another cornerstone. He's been around for quite some time. But with that change came some other management changes, including mine. I became the senior vice president. So I am an officer of the company now, and I am the director of business development, risk management, communications, and whatever else that Tom asks me to do a given day. So that's me, and we're a smaller company. We have 10 employees, and most of us wear several hats, as I'm sure many of your listeners are used to hearing or maybe even experiencing as small businesses. There's a lot to do. And so we all participate, and we're doing well.
That's great. Yeah. And I'm sure listeners, if they've attended any state bar conferences and functions, WILMIC is almost always there 100% of the time, darn near. So that I really enjoy that you guys have that presence. So we appreciate that. Where I get the questions from members in my role at the State Bar is kind of on both ends of the spectrum. I'm starting a law practice, I'm going out on my own, or I'm leaving a practice to start my own. And I'm wrapping up my practice, I'm either leaving the law or retiring in some way, shape, or form. What do I need to do from a malpractice side? So I guess, can we start there at that kind of beginning, that initial call that I would get, and then I recommend giving WILMIC a call to talk through all those big questions you have, but kind of give a rundown of that breakdown of what is malpractice insurance? What are we talking about here? What does it cover? Why do I need it? All of those types of questions.
Yeah, and that's a great place to start, Brent. And it really is just circling back to your comment about how WILMIC is present. It's important that we're present to speak to Wisconsin's legal community, because there are so many nuances and so many differences and maybe explanations that aren't expected from potential policyholders or lawyers just looking for legal malpractice coverage. The typical concerns are, oh, geez, legal malpractice is such an ugly word. This is going to cost an arm and a leg for me, to be able to have a policy. Is that something that's going to be cost prohibitive as I start up my practice? I don't have a huge client base. I just got out of law school. Whatever the case may be, that can be a little daunting. But so many more positions can go into answering those questions. What do you have to protect? And I think one of the considerations that lawyers ought to be aware of is you have a duty of professionalism, not just to protect yourself and your assets and your practice, but also what would it cost a client if you make a mistake? And if you're not in a position to be able to respond in that kind of a situation, your legal malpractice carrier will be. And so it's good, not just for your peace of mind, but also for your client's peace of mind, because let's face it, lawyers are human, and humans make mistakes. So there are professional reasons, of course, to have legal malpractice insurance. It's also likely that if you are going out on your own, that you're going to organize as a limited liability entity. And there are rules out there, specifically Supreme Court Rule 20:5.7, which talks about the need not just to have certain limits of legal malpractice insurance based on the number of attorneys in your firm, but also a reporting requirement to the state bar that you have secured such coverage. So right off the bat, there are some reasons, cost aside, there are reasons to obtain a good lawyer's professional liability insurance policy. Coming back to cost for just a minute. So legal malpractice policies are claims made and reported policies. And we'll talk more about what exactly that means from a claims perspective, but from a risk perspective, one of the things that a claims made and reported policy requires, and one of the effects of it is to sort of lower the risk to the carrier based on reported claims. So when a lawyer will apply for insurance, there's a long questionnaire, and we always get a lot of flack about how laborious it is to complete the application, and we do our best to assist with that. But the reasons are based on what have we, WILMIC, what have we experienced, and what have other legal malpractice carriers experienced in the form of claims. What's the frequency out there right now? What's the severity right now? And again, we'll sort of get into some of the granular specifics as we go. But there are areas of practice that are riskier than other areas of practice. Sometimes that's due strictly to volume. There are a lot of lawyers doing certain kinds of work. And a lot of times it's, when it comes to severity, it depends on what kinds of work you're doing. Does it have to do with a very valuable estate or a very valuable piece of real estate? Those are the kinds of things that can play into, those are some of the factors that would affect the cost of the policy. But starting right out, if it's your very first year, whether it's because you just graduated law school or you've decided to make the leap from a firm to go out on your own, you may not have a whole lot of risk accumulated. And claims made and reported policy takes that into account. So as the risk accumulates or becomes more and more and grows more and more, your premium is going to go up. Now it's not forever, and it does plateau after about 6 years. But initially, you're looking, depending again on what kind of work, how many lawyers, you're looking at something that's less than $1,000 and probably closer to $500 just to get a policy in place and start off on your first year of practice. As that practice grows and you get more and more clients and more sophisticated matters, obviously that's going to play into your premium. And like I said, that plateaus after about 6 years. And then you have a pretty constant policy, assuming you keep the limits the same, the deductible the same. All of those kinds of factors, I think, will kind of level out. And then you'll have a pretty steady idea about what your cost expectation is for a policy. I'll pause there, Brent, because that was a lot.
No, one thing you've said, claims made, and I guess just to kind of focus on that to make sure that attorneys are clear on that. I have heard attorneys that say, you know what, I had insurance for, a couple years. I didn't practice as often as I was intending to when I went out. I was kind of part-time, and I'm going to stay that way. So I think I'm just probably not going to renew that. And I kind of explained to them, like, well, if you're not a limited liability entity, like you said, in Wisconsin, you aren't required to have malpractice insurance if you are a sole proprietor. But I always make clear that they understand what claims made means. So just because you had insurance 2-3 years ago when you were practicing, whatever case that was, and then an issue arises today and you no longer have coverage, then that coverage that you had then does nothing for you now. Am I understanding and explaining that okay to them?
Yeah, that's pretty accurate, Brent. It's not based on when you provided those services to the client, as you suggest. It is when the claim is made. That is the important date. Oftentimes, especially in practices like real estate or estate, probate, and trust, the actual legal work is done years, sometimes decades beforehand. And the error is not realized until there's some other event. The death of the client, for example, for somebody who is drafting a will, or the sale of whatever real estate was the subject of the legal representation isn't sold for 20 years. Those are the situations. We have a statute of limitations in Wisconsin. It is not a statute of repose. And the statute of limitations for legal malpractice actions is 3 years. However, there is a case out there, Bleecker v. Cahill, which talks about the discovery rule. And the discovery rule basically says that whenever the claimant discovers the error, or discovers the injury rather, then that is when that 3-year clock will start ticking. So that case centered around a real estate transaction. There was an error in the drafting, alleged error in the drafting. And the immediate response was, hey, this was 10 years ago. You're beyond the statute of limitations. This case should be dismissed. Court said no. The claimant did not discover it until whichever part of the contract, I don't know the specifics, but whichever part of the contract triggered the injury to the client, that's when this started to run. So at that time, it was actually a 6-year statute of limitations. So it changed the overall calendar to 16 years long. So the claim wasn't made until the injury was discovered, or should have been discovered, is the key phrase there. And you're absolutely right. When under a claims made and reported policy, you have to have an active policy in place at the time the claim is made, not the time the error occurred. So those that sort of, we call it, choose to run naked or create gaps in their coverage are taking a real risk. And we try to, again, by trying to be present in the legal community and explain it as many different ways as we can, we try to help policyholders and lawyers avoid those kinds of gaps. You mentioned the possibility of a lawyer leaving a firm and what should they do under those circumstances. A lawyer who chooses to leave a firm has a couple of options to sort of mind the gaps. One is to secure an individual tail policy. WILMIC's philosophy is that is the best way to protect yourself anytime there is an event like that where you are going to create a gap in your coverage. So if you work at Hoeft Law Office for 10 years and you decide to leave, then you should be in touch with Hoeft Law Office's carrier to ask them what tail options you have as an individual lawyer for your work while you're at Hoeft Law. And almost every policy I have seen does provide for the optional purchase of a tail or an extended reporting endorsement. It extends the amount of time for as many years as you decide to be able to report a claim as if you had an active policy. So the most common, especially in areas of practice where there is that long shelf life of a claim, the most common tail or extended reporting endorsement would be an unlimited tail, and that would just go on forever. So that even as you go on your merry way and even past your lifetime, if there is a claim that's brought against your estate once you're gone, that policy will still respond. So it's important to consider that. The other possibility you would have is, wherever you land after you leave Hoeft Law Office, wherever you land, you have the option to purchase a new policy or to purchase different kinds of coverage from whatever firm has, from whatever policy that firm has that you land at. And I'm going to mention a phrase here. It's called prior acts coverage. You can put a retro date on your policy going forward. That's going to make it really cheap because that puts you back in the position of that first year lawyer who doesn't have any accumulated risk. It's a go forward policy, if you will. And you're in a position then where a claims made and reported policy is only going to respond to work going forward that you do. The other option would be to get what's called all prior acts coverage from the next carrier. That will cover your work back to whatever date you identify. Sometimes it's a retro date, a retroactive date that Hoeft Law Office had on you. Sometimes it's back to your date of licensure in Wisconsin. So there are questions to ask there, and there are options to consider whenever you decide to leave a firm. I think the other example, Brent, that you mentioned was, okay, what about retirement? What happens then? Mm-hmm. There are a couple of options, and one that's more popular lately, and it's not, I mentioned earlier that the single best way that you can protect yourself anytime you create a gap, and retirement would not necessarily create a gap, but it would create a need where you need to cover your past work. You could purchase that same tail that I described, and that would effectively cover you individually for all of the work that you did for that firm while you were there. So that is still a viable option upon retirement. The other option, and I've heard people describe it as a free tail or a complimentary tail or something like that. Chances are it's not that, and that premium was paid for it all along and worked into the underwriting calculus that generates the premium. But there is the possibility that a policy will cover you as a former lawyer. Sometimes that's in the definition of the named insured and all of the individual attorneys identified in the policy. Sometimes that's by way of an endorsement. WILMIC is offering that endorsement. We call it former lawyer coverage, and it will cover lawyers who were previously with the firm. And that may be a situation where when you retire, you still have coverage as long as that firm maintains a policy with a former lawyer endorsement. So there's a trust factor there. Are you in a position where you can trust your old firm, your prior firm, to maintain that kind of coverage that will provide you with coverage into the future as you enjoy your retirement? That's a question that only you can answer. Sure. And if you really want to protect yourself, take things into your own hands at that point and get yourself a tail so that you make sure that you have the coverage you need.
Sure. So the policies, do they run to the attorney themselves or to the firm or both in a way?
Both in a way.
Okay.
And so um, every policy or every application that we process has the named insured, which is the name of the firm. Now we have so many solo practitioners out there and who are not organized as a limited liability entity. Sometimes that's one and the same. But if they have more than one attorney, or if they do organize as an LLC, who is the named attorney that is protected? Now, an individual tail will run with the attorney no matter what. So if there is a retirement and the lawyer purchases the tail and the firm, the named insured firm, later dissolves, then that individual extended reporting endorsement still lives on. So I guess the answer to your question is it runs with both, and in different ways, slightly different ways, depending on the circumstances. So a tail will definitely run with an individual for as long as it was for the term which was purchased, and then if that's unlimited, that's forever.
Okay, that makes sense. When you mentioned the statute of limitations, and when you're considering a tail policy, so I assume, just to kind of close that circle. So if I spent my time practicing, we'll say, real estate law, estate planning, those would be the situations where it's very likely that if you're retiring, that you're going to want that kind of the tail coverage that goes on for infinity, because you never know, how long. It at least is going to need to be as long as the person who you represented is alive, and then a little bit more for their estate and everything to process and close, to where really that liability then would end up going away. And you can't really put a date on that. So it would probably be a safe assumption that if that's your practice area, that when you're done practicing, that is your best option, is to purchase a tail coverage that goes on without an end date.
The longest time period between the work performed and the claim having been brought to WILMIC is more than 20 years, fewer than 25 years, somewhere in that window. And I believe that one was a real estate matter.
Okay.
So again, the work was done, 23 years ago, and the error wasn't discovered until the owner of the property went to sell the property, and there was an easement on it that shouldn't have been there, or something like that. Yeah, those are the two practice areas where you're going to have that really long shelf life. Now, the thing about those practice areas is that a lot of lawyers practice in those areas, and so that's important for everybody to consider. Now, there are situations where lawyers, it's not cheap. Okay, the extended reporting endorsement is it's got its own formula, and it's sometimes 2.5 to 3 times what the individual attorney premium is. So when WILMIC provides a quote to a firm, there's a total quote, but then that's broken down based on the characteristics of the attorneys. A half-time attorney is going to have less premium than a full-time attorney. A lawyer with 2 years of experience is going to have a smaller premium than somebody with 20 years of experience.
Sure.
So based on which individual is contemplating purchasing a tail, the calculation will be different. And the last one I described will be the most expensive one, that lawyer who's been there 20 years and is full-time, because then all of those factors are higher. So those particular practice areas are the ones where you should sort of ignore the price tag and put something in place. There are other practice areas where maybe it's less important. I think, to be absolutely sure and safe, my position has to be, you should get a tail, and it should be unlimited. But there are areas where the outcome immediately, and there isn't any sort of there isn't as significant a threat of later discovery of the error. For example, criminal defense. It's one of our more frequent categories. It happens to enjoy, what's referred to as the actual innocence rule, where if you are a criminal defendant and you want to bring a claim against your defense lawyer, you have to be able to demonstrate that you are 100% innocent of the crime that was alleged. And so that's difficult, especially when we start talking about things like plea bargains, because you're admitting that you're guilty of something. But there are some cracks in that, and that's a topic for a whole nother day. But my only point is that criminal defense lawyers have less of a severity problem, but more of a frequency problem, which just means that we see a lot of grievances filed against criminal defense lawyers because sometimes their clients end up with a lot of time on their hands, and they want to blame somebody for whatever is wrong with their lives or life. And so they would bring that kind of a grievance. A legal malpractice claim is not likely after that 3 years runs. That's it. They knew or should have known what the error committed by the attorney was when the verdict came back. Whenever the litigation was done, whenever the prosecution was over, that's when that clock starts ticking. So do you need an unlimited tail? Maybe not. That's a business decision. But remember that the statute of limitations on bringing grievances is 6 years. So, and at that point, 6 years is no different than unlimited as far as price goes, at least with WILMIC. So there are still reasons to purchase tails in every practice area, but those that you mentioned and ones like them, where the injury it's possible that the injury won't be discovered until many, many years later. It's very important to mind that gap and get that tail in place.
And now, a word from our sponsors.
Hi, Russell Nicolay here with Nicolay Law, Accident and Injury Lawyers. If you have clients that have been injured, my office would love the opportunity to help them get compensated and get their life back on track. We handle referrals and co-counsel relationships on injury cases all across Wisconsin.
WILMIC comprehends the unique challenges faced by legal professionals. This understanding is fostered through WILMIC's active participation in various legal gatherings, from state bar committee meetings to seminars and conferences, enabling meaningful dialogues and profound insight into practitioners' needs. Put your trust and your premium with an insurance company that supports Wisconsin legal associations and events.
Thank you. And now back to the Practice Pulse podcast.
You made a mention of kind of trends and how sometimes frequency and the amount of claims aren't always tied together, that sometimes you see more frequent claims but not payouts and vice versa. What are you seeing in terms of trends in your industry right now?
Yeah. Well, Brian Anderson is our director of claims at WILMIC, and he does a summary for us every year about what's happening. And he is, we're all very happy that claim frequency has been going down for several years. That downward trend started in about 2016. I'm sure it has everything to do with the fact that I was there in 2016 and I started doing all these great things.
Sure. Yeah, that sounds right.
More likely, I think we are doing our best to get out in front of a lot of these matters, and we're encouraging a lot of our policyholders to talk to us. There's no harm. It's not like the chip in your windshield that automatically makes your auto insurance premium go up, without real good explanation.
Sure.
We actually look at it exactly opposite. When we have a policyholder who makes us aware early about a matter, then we have the opportunity to use, Brian's 20 years of experience and in my experience since 2016 to get out in front of those matters and really stop them before they become claims. So while our claim frequency has gone down, we have two different measures. We have the claim frequency, which is strictly a claim, a client. I'll talk more about the definition of a claim, but the client really did complain about something that you did and demanded something in return. Yes, the frequency of those kinds of matters is at historic lows. And what we think that means is that there's a strong risk awareness among our policyholders so that they feel comfortable calling and talking to Brian. If you know Brian, I always kid him because I tell him that he's 6 feet 13 inches tall. He's a gentle giant, and he really is responsive and understanding, and just doing his best to be helpful in some uncomfortable situations. As far as which practice areas are generating those, it's the same areas that we just got done talking about, Brent. It's estate, probate, and trust. 24% of our claims last year came from that practice area, and that was the highest. And I think there are a couple of things going on there. One, estates are becoming so large, and there is a lot of wealth out there and a lot of money for those people that do hire lawyers to prepare an estate plan for them, and they grow over time. Family dynamics aren't always excellent, and so there are some nifty things that you can do with estate plans, and there are some insulting things that you can do with estate plans. And if you're out to get, one potential beneficiary over another, or you're trying to put one in a better position than another, those kinds of exercises can be accomplished. What it does, though, is it does generate and sow resentment, so that those who are disenfranchised beneficiaries may just take a wild, stab at a claim and say it's the attorney's fault. There are pretty good defenses in those situations. The disenfranchised beneficiary is not a client of the lawyer who prepared the will for the deceased, but there are some cracks in that armor, if you will. So that it's when the estate is $19 million, it's worth taking a shot and taking a small settlement just to get something. So I think a lot of that does happen. I think family dynamics are different just because they are. There are many blended families, and that doesn't always mean that there's harmony in the family setting. Yeah. So those are the kinds of things that contribute to that. Real estate, we mentioned, that's number 2. It's 16% of our claims. And same thing there. I think a lot of the same dynamics are at play. And then third, family law. Again, that's a trend, where there's that kind of discourse that can lead to pointing the finger at somebody. And more often than not, it's the lawyer.
Sure.
And then criminal defense and business transactions or commercial law, that would round out the top 5. It's interesting, at least with respect to frequency. A personal injury plaintiff's practice had been, our annual top 5, and this was the first year that it was not in that category. That may be, and this is a topic I know near and dear to your heart, Brent, technology driven. There are more tools out there that allow for redundancy and calendaring. And one of the biggest errors that we had with personal injury matters, especially when lawyers would maybe venture out of the state that they're used to practicing in, is a calendaring error where they miss a statute of limitations. Yeah. So that's frequency. Severity, very interesting to me, is that nearly half of the money that we paid out, actually more than that, almost 75%, as I'm looking at. Let me just do the math here. I am a lawyer. I didn't know there was going to be math. But hold on.
Right.
Yeah, it's
75. Mathing is not my strong suit either.
I'm glad I'm not alone. So 42% of the dollars paid out by WILMIC last year were in estate, probate, and trust, and 35%. So 77% total between those two practice areas: estate, probate, and trust, and real estate.
Okay. Is that, do you see a lot of movement from year to year of those top, I guess, let's say top 3, those, especially those top 3, or is that pretty standard that you're going to assume that those 3 will be there? Maybe they may flip-flop 1 and 2, but those will be the top each time.
Yeah, we usually do have, this has been a trend for the last few years. I would say, the last 3 to 5 years, estate, probate, trust has really been moving up, or down, however you look at it. Yeah. And in real estate is one of those where you have one transaction or one land transaction that can really kind of skew the numbers a little bit. But it too has been more present in this category in the last few years. The one that has sort of left the top five is personal injury plaintiffs work.
Yeah.
And that is not consistent with the last 39 years of our existence. So there are some shifts, and I think we're seeing them and appreciating them. But that's where the frequency and the severity fall, at least with WILMIC. Now, we do have occasional claims that will come in, and one area that is particularly impactful in that regard is intellectual property. Whenever there's patent litigation or trademark litigation or things like that, all the same kinds of concerns come into play. How much money are we talking about? I would suggest that those kinds of claims are a little more speculative, especially when we're talking about future earnings that were lost because a deadline was missed to file a foreign patent. But we've had a couple of those that really just are frustrating because the folks who feel injured think they have the best thing since canned beer, to sell, and the lawyer screwed it up their plans. But they are less. They happen less often, so the frequency, thank goodness, isn't there as much. So we can still sort of absorb those.
How about ransomware, data breaches? What are you guys seeing there?
So the cyber insurance market is really coming around. There are more options. The carriers, I think, are figuring out ways, including WILMIC, are figuring out ways to write that kind of coverage. And what we did was partner with HSB, who had a very good cyber suite package. And, we handed over, what our book of business looks like. And they came back to us with an underwriting profile that allowed us to provide insurance in a meaningful and affordable way to the majority of our policyholders. That's good news. We do not, and we don't pretend to be cyber experts, and I don't think we have the capacity to take on that kind of insuring. We do it with a partner who does know those things, which, the general message there is just one of networking. If you're not going to be an expert in an area, find somebody who is and partner with them somehow, some way. So as to the specifics of things like ransomware, I'm not the right guy to answer that question. But there is interplay between your lawyer's professional liability policy and some of these cyber attacks that happen. Ransomware isn't the best example of that sort of interplay because that really is a first party claim. They took your files, they're holding them. There is some response from your LPL policy because there may be requirements to notify your clients, which may generate a claim. This was taken, nothing was done with it. Usually that means no harm, no foul. We got the records back, or we had sufficient backups so that, all of that was taken care of. But you need to be aware of it. That could lead to a claim down the road if there was any negligence on your part. Where we see more of the interplay and more of the response from the lawyer's professional liability policy is in social engineering claims. When lawyers and real estate happens to be one of them. And frankly, this is one of the reasons why that part of the severity pie was so large for real estate, was that we had lawyers who were in the final stages of a real estate transaction, and that hacker picked one of the parties in the transaction and stole their identity. Basically, that's the social engineering part of it, and then pretended to give wiring instructions or something like that to dupe our lawyer or our lawyer's office into sending money somewhere that it didn't belong. Things move so fast these days that anytime wiring money comes into play, we encourage our policyholders to slow it down and do the two-step. Verify, one, is this an email that I expected from this particular person? Is it consistent with what we agreed we were going to do about handling payment at the end of this? And then pick up the phone. That's the second step. Go low tech, verify it. make sure that money doesn't leave. And that's hard. There are all kinds of pressures and expectations of clients to move things fast, but you really do need to slow those things down to avoid that kind of a harm.
And now, a word from our sponsors. Would you like to implement new efficiencies into your law practice but don't know where to begin? Practice 411, the State Bar of Wisconsin's Law Office Management Assistance Program, is the place to start. Don't wait. Contact Practice 411 today for a complimentary and confidential consultation at 1-800-957-4670. Thank you. And now back to the Practice Pulse podcast.
Claims. You mentioned claim in multiple scenarios. So what exactly constitutes a claim? Also, you said that you encourage your policyholders to have an open dialogue, that if something, maybe I catch something and this makes me nervous that this could arise to a claim down the road sometime. Does that constitute a claim? Does that also constitute the time in which an issue was discovered? So if I discover it versus a client discovering it down the road, does that have bearing?
It does. Claim has a specific definition in our policy and probably in every policy. And in our policy, it means your receipt of a demand for money or services naming any of you and alleging a wrongful act. So a claim is something that would come from the client. And that's maybe the more obvious one. And I guess I'll put all of these under the general category of reportable events. So if a client contacts you and says you did this wrong and I either want my money back or you put your carrier on notice, there are a lot of different things that clients or others can say that would meet that definition and require reporting before it's covered. So claim is one reportable event. The one that you described is what I would categorize as a potential claim. And a potential claim is something that a reasonably prudent lawyer, a set of facts and circumstances that a reasonably prudent lawyer would think could give rise to a claim. The best way that I think I can describe this, just because I'm a geek, is to say when your spidey sense goes off and something is just off, and pay attention to your lawyer's superhero instincts and report it. There really is not anything that it's not going to affect your policy just to call up and report a claim. Now, I can't say that your spidey sense is dead on and it's going to lead to an indemnity payment, and just because you were good about reporting it, it's not going to rise. Anytime there's an indemnity payment, of course that is going to affect your premium. But reporting it and putting WILMIC or your carrier in a position to be able to get in front of it and repair it is not the kind of thing that is going to affect your premium necessarily. So it is important, not just to make sure that you trigger the coverage under your policy, but also that you put your carrier in a position to be able to resolve it or be able to assist you in resolving it and give you guidance along the way to help navigate those things. The third reportable event is a grievance. The thing about grievances is that anybody can file a grievance. There isn't a privity requirement there or anything else, and OLR will look into it. WILMIC's policy and other policies out there have usually something that we call it an additional benefits endorsement. It might be called something different, like grievance counsel coverage or something like that with other carriers. But most of those matters, those grievances, are resolved relatively inexpensively with an explanation of what exactly happened from the lawyer's perspective, not from the angry client or the angry client's mother who got upset at a family law matter or other person who reports it sort of inaccurately. We encourage our lawyers to use that part of their policy. One, there's no deductible. So there's nothing out of pocket for you as a policyholder. And two, it's a pretty emotional thing to have your license be put on the line, because a grievance is filed against you. And that may put you in a position where you're not the best person to respond for yourself anymore. And so, rather than getting emotionally wrapped up in it, taking away your billable hour time. Why don't we put this in the hands of an attorney who's been there and done that and is familiar with OLR, what they're really looking for? So it's important to stay focused. And I think sometimes under those emotional circumstances, it's a good idea to reach out to your carrier and see what options you have. But those are the three main ones as far as how to communicate with your carrier. Now, again, I encourage as much communication as possible. I just got a call the other day, a lawyer who was considering retiring, and he was asking about what he had to do with all of his files. Great conversation to have. Real practical kinds of things. And there are many times, Brent, whether you know it or not, but I refer them to you because you know the answer. And that's, again, part of our mission is to maintain that link, keep our finger on the practice pulse of the bar, and put in as many resources into play as we can to help solve problems.
Way to sneak that practice pulse in there like that.
I thought you would.
Yeah, and that goes back to kind of tying together when we talk about files and how long to keep files. We talked about statute of limitations, and the recommendation is that minimum of 6 years. That's really the floor, and that's why that we have the statute of limitations there. Now, of course, that's not every single case, as we also talked about with estate planning, real estate. There's other times when you should maintain those files for longer because of the nature of it, or minors are involved that, won't reach an age of majority before that, 6 years is up. There's some outlier scenarios there, but the standard recommendation is that 6 years because of that. So jump a little bit, I guess, sideways and talk about succession planning, because you and I have talked about this a lot. This comes up a lot. The kind of like unexpected, what happens if a lawyer is incapacitated or dies, and something needs to be done for the existing clients, and a plan needs to be put in place to protect those interests of those clients. In connection with that, I often get the question about, well, what happens with malpractice? What if I'm going to be that successor and somebody asks me to be that person for them? And I step in and I'm managing that kind of either wind down or triage of their practice and try to figure out the best way to handle the client. And maybe I discover like, man, this doesn't look like it was done properly. I get the question of like, what kind of liability would I have coming in there as a successor, and what do you recommend for that successor and planning attorney relationship in that scenario?
Sure. So succession planning, and you're right. A lot of the conversations that we have had, have centered on the idea that not enough lawyers have undertaken this plan, this succession plan. WILMIC has. And I would encourage anybody, it's available to anybody who wants to look at it on our website. We have a succession planning guidebook that Tom in our office drafted with the assistance of a lot of other practitioners who have been in different circumstances and generated different plans. Common to all of those that contributed to that book is the actual plan itself. You have to do something. You have to take that first step. It's the hardest one. But it is important, and it is important to, like you said, protect all the interests of your clients, and really your loved ones who have to kind of pick up the pieces if it is the situation where you have passed away or are incapacitated, and the legal community. Everybody sort of struggles if there's no good plan in place. And that struggle is definitely an environment that can give rise to claims. Deadlines get missed, small things get missed. Anytime there's a transition of a file, there's a chance that something gets missed. So a couple things. One, if you have a WILMIC policy and you pass away or you become incapacitated, we provide an unlimited tail at no charge. That's a given. And so there is that coverage at the outset. So check your policy and see if there is a similar kind of provision that allows for that extended reporting endorsement. While you go through the planning process and you identify a successor, one of your first questions for that, asking that person to be your successor, do you have lawyer's professional liability policy in place, and what are the limits? And if it's inadequate, then that's another conversation. It's either another conversation with another lawyer who should be the successor, or would you consider increasing your limits, so that we can facilitate this kind of plan as we go. That's a real consideration. And
Okay.
As the successor, I'm yet to come into a situation or be aware of a situation where a successor who is really sort of triaging the practice be the subject of a claim from another attorney. It's more likely that claimant is going to pursue a claim against the attorney who is either has passed away or is incapacitated. That doesn't mean it can't happen, and that's why you want to be sure that you have your own policy in place. I would encourage lawyers to really put that file in the best hands. And if they're not yours, find somebody who can handle that kind of a situation. So if it's in a practice area that you're not familiar with, exercise your network. Find somebody who is, and make sure that they are in a position where they can adequately review the file and do what they do best. If it is something that you intend to take on, understand that as successor counsel, if there is an error that you find in taking over that file and you have the time and the ability to fix it, you need to fix it if you're taking that file on.
Sure.
I'm not sure that there's an obligation to tell the client, oh, geez, I would have done A, B, and C differently, as long as there are different ways that lawyers can meet the standard of care in each situation. So that has to be, my response to that, Brent, has to be, every claim is treated as its own and evaluated on a case-by-case basis. But
right.
I don't think it means that you don't need to put yourself in a position of evaluating the quality of the work that was done. You need to move it forward.
Yeah, that's good advice in terms of when you're seeking out that successor to have that discussion, because it is a big responsibility. It's a big ask, and sometimes I recommend that people find the opportunity to have that kind of quid pro quo, like I'll be your successor, you be my successor, and sometimes that lessens the ask because you're agreeing to do that for each other, and it takes care of two conversations in one. That you can have those conversations more easily. Well, this has been great. A lot of good information, I know that members will find helpful, because I get lots of questions on this kind of stuff. I like to end each episode with kind of a takeaway from members, one key takeaway or piece of advice, or maybe even in your case, like one thing you wish attorneys knew just coming to you before they even came to you. One thing that you see over and over again, like, please understand this, attorneys. And what would that thing be?
Well, I just wrote an article for Wisconsin Lawyer, and I quoted George Bernard Shaw again. And I'm going to screw it up if I don't look at it. But the single biggest illusion in communication is that it has actually occurred. And that may be not word for word, but that's the gist. And it's so important on so many levels. I would suggest that the biggest reason why clients become upset is because there is a lack of communication from their lawyer. And staying out ahead of that and recognizing all of the different ways that you can communicate with your client will help you avoid so many of these kinds of situations that we've been talking about: the claims, the potential claims, the grievances, all of those things. But more importantly is that communication is so important on so many levels, including your relationship with your legal malpractice carrier. Because we often get asked, well, what do I need to report? And Sally Anderson, who was my predecessor, said, well, anything that you want covered. So you're not going to have coverage if you don't communicate that when your spidey sense goes off and you are aware of facts and circumstances that just give you pause.
Yeah.
Pick up the phone. I promise we don't yell at people. We listen. We try to understand what the problem is or might be. And then we do our best to exercise our network, and it's pretty big. As you know, we insure almost 3,000 lawyers in the state. And so we have occasion to talk to a lot of lawyers in the state who probably have been there, done that, regarding whatever your situation is. So, I guess those two things, if you maintain high levels of communication and effective communication, both with your clients and in the context of this conversation with your legal malpractice carrier and your state bar, I think you're putting yourself in a position of strength to be able to avoid these kinds of errors in the first place, but also to respond to them when they do happen.
Absolutely. I think that is a great tip. And it is exactly what I hear. I hear it from OLR that, one of the biggest complaints is essentially just a communication problem, that I can't get a hold of my attorney. My attorney doesn't respond to me. I never know what's going on. Those types of things. If you can get ahead of the client having to call and check in on their case, that makes a happy client, that even if you reach out and say, just wanted you to know, checking in, nothing's going on, but we'll let you know when something is, and give us a call if you have any questions. Just those little extra efforts like that in communication can go so far in terms of a happy client, and therefore you don't run into OLR, you don't run into having to exercise your malpractice insurance policy. So that tip, I don't think it can be stressed enough. I think that's right on.
Excellent.
Well, Matt, thank you. I appreciate your time. I appreciate all the information, and I'm always happy to work with you and talk malpractice insurance with you, and keep up the good work.
Right back at you, Brent. I appreciate you.
All right. Take care, Matt.
Thank you for listening to the Practice Pulse. The views expressed by the participants of this program are of their own and do not necessarily represent the views of, nor are they endorsed by, the State Bar of Wisconsin. None of the content should be considered legal advice. As always, consult a lawyer.